or a second guessing by the President. Once the JSC makes recommendations, the President has no option but to formalize the appointments. The court ruled that the President cannot change the list, review it, or reject some names. He cannot decide to cherry pick from the list of nominees. Both courts ruled that the President must appoint the persons as recommended and forwarded to him by the JSC, since the President has no residual legal power to question or reject names recommended to him by the JSC for appointment as judges in accordance with the Constitution. The Constitution does not donate any mandate to the President to perform any other act upon receipt of the names recommended by the JSC except to appoint them. Both courts categorically held that the refusal by the President to appoint the 41 judges was a grave violation of the Constitution. Having reached that decision, the court in petition number 369 of 2019, consisting of 5 judges, directed the President to appoint those judges within 14 days. The Attorney General, as is now his practice, filed notices of appeal, but he has not done anything to prosecute appeals, if any, from those decisions. Neither has he obtained any stay of execution in either of those cases. The legal position, therefore, is that the President is obliged by the 2 court-valid orders to appoint the 41 judges within 14 days of the decisions of those 2 courts. The President's disregard of court orders does not bode well for our constitutional democracy and is potentially a recipe for anarchy. Besides the court orders, I have challenged the executive to table before the JSC the alleged information of lack of integrity it has against some of the 41 nominees. Some of the individuals the executive claims to have adverse information against are serving judges. If the executive's allegations are true, these persons should not then be serving as judges. However, no evidence whatsoever has been availed to the JSC, both during the interviewing process and after. Unfortunately, this disregard of court orders by the President is part of the pattern by the executive. It is important to remind Kenyans that in addition to these 2 specific orders, the executive routinely disregards court orders. For example, despite an existing court order, the government recently evicted over 1,000 families from the Kariobangi area of Nairobi, all in the midst of the COVID-19 pandemic. Additionally, the government has willfully neglected to settle dozens of court decrees issued by various courts against the government. These court decrees amount to almost 1 billion by conservative estimates. And they go back several years. It's not recent, they go back several years. Many of these decrees arise from personal injury claims by victims of road traffic accidents caused by government vehicles. In some of these cases, the victims have suffered paraplegic injuries. Yet, the government has failed to settle these decrees. because they cannot afford to pay for nursing care. Some are carried, I'm told, by their grandchildren to bask in the sun and at times forgotten to be rained on out there. Attempts to compel the accounting officers in the relevant ministries are always rebuffed with the contemptuous utadu attitude. How can we expect God to bless our nation when we are so callous with the most desperate in our society? There are many other court decrees and orders which require the assistance of police to execute, which have been neglected and disobeyed. As a result, many decree holders are unable to realize the fruits of their judgments that they have obtained from courts. Your Excellency, I want to address the President personally. Your Excellency, you know I have respect for you as our President, and I have told you that. You also know that I have, for a long time now, unsuccessfully sought an appointment to discuss this issue with you, leaving me with no option but to raise the matter through this public statement. It will be at the direction of my duty if I do not raise Wanjiku's agonies in my domain. At least let her know that I share in her frustrations. It is for this reason that I must remind you, Your Excellency, that you swore to defend and uphold the Constitution and the laws of Kenya. The Constitution, as the two multi-judge court cases held, requires you to appoint judges recommended to you by the JSC, which you have refused to do. The laws of this country include valid court orders. It therefore behoves you to appoint the 41 judges recommended for appointment by the JSC as ordered by the court without any further delay. As Your Excellency has pledged in the past, you respect the rule of law. I urge you to now demonstrate that faith and respect the rule of law by complying with those two court orders. In so doing, you will also alleviate much suffering for Kenyans who are seeking justice in our courts. In the same vein, I request Your Excellency to instruct the Attorney General of the Republic of Kenya to take stock of all the court decrees and orders issued against the government and to immediately begin a process of satisfying them. It greatly undermines the rule of law for the government to act in defiance of court orders, and this pattern puts a great risk to our constitutional democracy because it risks the contagion of lawlessness. The government should be in the forefront in upholding the rule of law. The government cannot demand of its citizens the obedience of the law it is itself disobeying with abandon. Thank you.